Good evening. Happy Saturday. On the 27th of September, the trial of News Now Houston, aka News Now Community, aka Earl David Warden, a registered public sex offender who is currently set for trial. He's currently set for trial on charges of sexual molestation of a sexual assault on a minor, age 13 to 16. That was his daughter back in 1994-ish. It was set for September 27th. There was some jiggery pokery going on. I don't know exactly why. I have a feeling there was an issue. Really, dude? Like, really? There we go. All right. So there was an issue where it was set on 7/13. It was set for 9/15, and all the subpoenas went out on 7/13. And then it was reset for, I think, 9/21 and then 9/27. And this one right here is the only one that went out in time for the 9/27, and that was by Earl. That was his son, Earl Warden Jr. And so there was an issue. So it did not go ahead on 9/27 because, again, I think there was something weird going on. You see this one right here. It was reset for 9/15 on 7/13, and then there were a couple other entries in there that have disappeared. Now, this is not the record. The record is the actual clerk's file in the clerk's office. This is just an online representation. Anyway, so when that 9/27 hearing went away, Earl started talking about how his attorney was really pissed because the DA just went and changed dates and didn't tell anybody. And so Earl's attorney was pissed, and Earl's going to get the case dismissed. And I pointed out several reasons why I didn't think that was the case. One of the big reasons is this is Harris County local rules for criminal cases, and this is section 6.19 on continuances. When a case is to be rescheduled, the reset agreement, it's an agreement, must be prepared by the attorney seeking the reset and concurred in by opposing counsel. So they have to be, both attorneys have to be in agreement to request a continuance, a resetting, or a postponement. Now the court can do it on its own. But attorneys, even off-docket requests, again, they have to do the reset agreement, and it must be prepared by the attorneys, plural attorneys. So again, it's an agreement. And so all of the continuances that have happened where it was reset upon prosecutor's request or reset upon defense request, all of those, both attorneys joined in on. So his statements that his attorney didn't know what was going on is a lie. And I pointed that out in my Discord, and so now Earl, on I believe the 5th, says that he's invoked his right to a speedy trial. I had pointed out that Earl had not, up to that point, invoked his right to a speedy trial. Now, I don't know how he invoked his right to a speedy trial. You can invoke it just by telling the DA in the court, hey, I'm ready for trial. I want to go to trial. I'm invoking my right to speedy trial. I want this to go to trial. I want speedy trial. You could do that, and that's a fine way to do it. A better way to do it is to actually file a motion. It's a demand for speedy trial. It is a motion. The court will hear it, and the court will then make sure that you get set for trial at some point in time, reasonably soon. Now, Earl is already set for trial in December. So if he files a motion now, I don't know exactly what that's going to do, if anything. It would just get heard before the trial that's already set for December 7th, and assuming the trial goes ahead in December, and the court is probably not going to grant it based on there's a 4-part test that we'll get to in a minute. But he says he's invoked his right to a speedy trial. The state must, by law, bring me to trial by November 3rd or dismiss. That's a lie. That's not true at all. Just because he's invoked his right doesn't mean that the state has 30 days to do it or less. Apparently, if they invoked it on or about the 4th, that doesn't mean shit. It does mean that now the clock is ticking, and now it's more likely that the case will get dismissed. The longer it takes after he invokes his right to a speedy trial, the more likely it is that the case will get dismissed for violating his right to a speedy trial. But there's no rigid deadline. There's no 30-day rule anywhere. He says there are no other options. Again, that's a lie. My lawyer will also be filing a motion to dismiss for lack of prosecution since we've been ready for trial since last January 1st. It's not when you're ready for trial that matters. What matters is when you've invoked your right to a speedy trial. That's what matters. That's the only thing that matters. Being ready for trial is just being ready for trial. It doesn't mean you're demanding your speedy trial. Again, that's nonsense. They will have to schedule a motion hearing by law once it's filed to have the judge rule on the motion or to dismiss that day. Yes, if he files a motion to dismiss, it'll probably get heard right before trial, or the court will reserve on it and will rule on it after trial. There's no other real requirement that I'm aware of. He says you don't need to keep checking the website. Once there's a date, I'll let everybody know it's going to be glorious. So there is no date for a trial or for a motion hearing. I again am going to assume that his motion to be dismissed will be heard on the day of trial. But we'll go ahead and see. Now, what is speedy trial? The Sixth Amendment guarantees your right to a speedy trial. The accused shall enjoy the right to a speedy and public trial. So that is one thing that you have a right to. Barker versus Wingo is a United States Supreme Court case that set forth a 4-part test for when your right to a speedy trial is violated. In this particular case, the Barker, I believe, was the defendant in the criminal trial. He was fine letting the time run. He was fine not doing anything because there was a co-defendant, I guess, who, if that co-defendant was not charged or found not guilty or something like that, then Barker had a much better chance of prevailing at trial, at his own criminal trial. So he was fine letting everything go until all of a sudden that other guy's case was resolved, and then he filed a motion to dismiss. He went from just being okay with it the entire time. Him and his attorney were just Jim Dandy with all the continuances, and it was 5 years of continuance or thereabouts. So everything was fine, everything was great, until all of a sudden he's like, "Oh, your motion to dismiss, you violated my right to a speedy trial." And so the Supreme Court developed this 4-part test. And one of the things that the Supreme Court looks at in their test is whether or not the person filed or invoked and demanded a speedy trial, whether or not the defendant was looking for a speedy trial or whether the defendant was looking to get their case dismissed. There's a distinction there. Every defendant would love to have their case dismissed, but you don't have a right to have your case dismissed. You have a right to a speedy trial. And so you should be demanding your speedy trial. So there are a lot of similarities between this case and Earl's case in that he was fine with everything going along swimmingly and slowly until all of a sudden he wasn't. And then instead of invoking his speedy, he talks about filing a motion to dismiss. I don't know if that's actually happened or not, because Earl talks a lot of shit that doesn't mean anything, and his lawyer is, according to Earl, the second best defense lawyer in Harris County, and I'm assuming that his lawyer is reasonably competent and isn't going to do things that are going to jeopardize his client's case. And he probably is not very happy with Earl running his mouth like Earl likes to do. Now, there are also a couple cases, Texas cases, that are useful. There's Cantu versus State. It is a Texas Court of Criminal Appeals case from 2008. The Texas Court of Criminal Appeals is the highest court for criminal cases in Texas. The Texas Supreme Court only deals with civil cases. Criminal cases go to the Texas Court of Criminal Appeals. That's the final highest court in Texas for criminal cases. So consider this to be a Texas Supreme Court ruling for those of you who are used to dealing with the Supreme Court being the highest court for criminal cases. So they also look at the Barker-Wingo factors, and this case had a lot to do with dismissal, because in this particular case, the guy was charged with he was arrested for drunk driving, and then 16 months later, he was finally charged with it, and he went boom and filed his motion to dismiss for violation of Speedy. And one of the things the court looked at, the big thing the court looked at, was what did he do to assert his right. Another case that I think is pretty interesting is Dragu versus State. Again, it's another Texas Court of Criminal Appeals case, and here the appellant failed to assert his speedy trial right for 3.5 years, and Earl also has failed to assert his speedy trial rights for 3.5 years, from February of 2019 until September of 2022. That's about 3.5 years, a little more, but right about there. So he failed to assert a speedy trial for 3.5 years until just before trial, although he was represented by counsel at all relevant times, and no question is raised as to the competency of such counsel. Again, Earl's been represented at all times, and there has been no question raised as to the competency of Earl's counsel. In fact, Earl seems to believe that he's the second best criminal defense attorney in Harris County, so that would indicate he's fairly competent. The Court of Appeals excused appellant's failure, holding that in failing to assert his speedy trial rights, appellant was merely acting in reliance on the state's assurance it would dismiss. That was an error, blah, blah, blah. In view of the length of the delay here, in which the appellant has quietly acquiesced, this factor weighs heavily in finding a violation of the right to a speedy trial. So not doing something until the day before trial, that's not a real good look. It's not a real good look. But anyway, the four factors are the length of the delay and the reason for the delay. Those are two things that are the state's burden. The length of the delay, the state has to justify why it took so long. The reason for delay, bad faith actions by the state are looked at differently than it's the state's fault, but it's not done in bad faith. Like, we didn't have enough lawyers for it. We didn't have a courtroom available for it. It's the state's job to make sure there are enough prosecutors available, there's enough courtrooms available, etc., that these trials can get done in a timely manner. So those are the two things that really are the state's burden. The assertion of the right, that is really on the defendant, and that's a major factor. Was the defendant pushing for that speedy trial? Well, if Earl's waiting until now, 2 months before trial, to start asserting it, there's been about 3.5 years of him not asserting it. So, that's going to weigh heavily against him. And then the other thing is prejudice to the accused. So the defendant has to prove the assertion of the right. Prejudice to the accused is a flip-flopper. The defendant has to show some prejudice, and it's fairly easy to prove you've been prejudiced by this, but you have to show something. And then once you show something, like I lost my job because of the delay in trial. I had to put off I had to put in so many days off of work to appear for trials that just got continued, that cost me my job. That might be enough. That probably is enough to show some prejudice. And then the burden shifts to the state to show that it's not really that prejudicial. So that's a flip-flopper. So those are the things that a court is going to look at. The cases that I have seen, they really indicate to me that Earl does not have a good case for a violation of his right to speedy trial. I have had several people ask me about it. So there you go. There's my best explanation. Remember, I am not a Texas attorney. I am not licensed to practice law in Texas. This is not legal advice for Texas. I am a first-year family law attorney licensed to practice in California. And that's about it. Thanks for watching, and have a great evening.